This is Attorney Mike Grevlin coming to you from Chicago as usual, and today I've got a fun one. I have to give a shout out to Cheeky Monkey who made me aware of this. He sent it in Discord. Of course, it's Judge Simpson's call, and it gets pretty wild. But while I was looking for that clip, I found some other good stuff, and it's all pretty interesting. Let's do it. From the secret headquarters of the Sovereign Citizen Patrol, initiating video production sequence. We are no longer playing. So let's get revved up. It's time for Law Talk with Mike.
Courthouse case of the people versus Ryan Mack.
I'll cover that if Mr. Gaddy's not back yet.
Good morning. Mr. Mack is refusing to come to the courtroom this morning.
Okay. All right. Let's put the appearances on, folks.
Good morning, Your Honor. Elizabeth Andery, Assistant Prosecuting Attorney on behalf of the people.
Your Honor, Lauren Brown, Deputy Chief Public Defender and potential Lions first round draft choice, appearing with and on behalf of Mr. Mack.
Then they will still be playing like they are. Okay.
I see Mr. Gaddy's back. We called
He's
Ryan.
the second choice.
Yes.
Again, no improvement. Courthouse case.
Okay, so we start charming, but don't worry, it gets wackier.
These people versus Xavier.
Going quick. I mean, well, they just adjourn it. Right? They're like, hey.
Good morning, Your Honor. Amy Reiser on behalf of the people on Xavier Anderson's file.
Good morning, Your Honor. Calvin Hawthorne, Public Defender Fellow, requesting permission to appear before the court with and on behalf of Mr. Anderson under Michigan Court Rule 8.120 and the supervision of First Assistant Public Defender Kalina Anderson.
Permission practice is granted. Good morning. All right.
Mr. Anderson is present today. Mr. Anderson, can you state your name for the record?
Xavier Daniel.
Judge, I apologize. Defendant is not dressed.
Okay. You're going to have to get him dressed, and I'll call him back up, but I'm not going to
Mr. Anderson, put some clothes on.
I just don't. I had numerous videos where people have done this before. I don't know how they're not getting the memo. I think eventually the judges are going to have to start cracking down and just holding him in contempt immediately for it. But I understand why they don't. I was watching this call. It's huge. They're taking care of a ton of cases. They're very efficient, honestly. But they're going to just have to crack down on this.
And don't forget to hit like and subscribe, or the dogs get it.
I'll pass it briefly.
Off.
Well, turn your camera off. Get dressed.
Court calls case people versus Joseph Bailey.
1-1. Okay. 0-1-1-1. Okay. Thank you, Your Honor. I wouldn't know for the record that.
Go ahead.
I wouldn't know for the record that we are all fully dressed.
And having seen you, Mr. Brown, thank goodness. All right.
Mr. Brown's a bit of a ham, but he's a good attorney. He really does know what he's doing.
All right, what's your next request?
The next request, Your Honor, is that Mr. Bridges is currently on a tether. I believe he's on a scram tether, Your Honor. Mr. Bridges works in construction, Your Honor, and he has to wear work boots as a part of his OSHA requirements. Apparently, the location of the tether on his lower ankle prevents him from being able to wear those work boots on the job site. So I guess he's asking that Your Honor either
buy him bigger boots?
I think he's asking.
I wish it was that easy.
It's funny you said that because it was exactly what I was thinking.
I didn't hear what he said, but I think he's asking that Your Honor consider another method of testing for him as opposed to the scram tether, and or I don't know if it can be placed on a different part of his body so that it does not interfere with his ability to wear boots, Your Honor.
What I will do is, so that he can work, I'll indicate the defendant may be switched to a SoberLink device. However, I'm specifically indicating two things. One, that instead of the standard 3 that we start with, defendant is going to be tested 6 times a day. They will lay out the time frames upon which he is to test. And then it is further indicated that if the defendant misses a test or misses the window in which he is to test, that will be considered a violation and the defendant is to be immediately remanded.
Thank you very much, Judge.
Thank you.
You understand, Mr. Bridges?
I put this over to the 19th.
Do I have to drive to these locations, or how does that? Is that a blow
Oh
machine? or
no,
something?
it's going to come with you. But
I'm
if you,
understanding
don't blow, if you don't blow in that device those 6 times within the window provided, it's going to be a violation, and then we will come get you.
That's classic Judge Simpson right there. He's posing as a tough guy, but honestly, he modified it so that the guy could go to work. He ultimately did him a favor, and now all he's saying is, "Don't burn me for it."
Oh, no problem. I'll blow in at any time. No problem.
Thank you.
Thank you, Judge.
Mr. Duzan, are you there? State your name for the record.
My name is Jacob Duzan.
Judge, in this matter, can we set up a Zoom preliminary exam, Your Honor?
You want me to first cancel his bench warrant because he wasn't here?
Yes, sure. I'm sorry. I've been bouncing around all morning. Yes, Your Honor. I do apologize. The client actually apologized to the court. He lost his phone. That being said, would you cancel the bench warrant and set a preliminary exam?
Mr. Kilwall, did you want to talk about a possible resolution, or is that just the position you're taking as you want an exam?
Well, if you want to adjourn it a week, sure, I'll discuss.
I'll adjourn it 2 weeks out, but he better be here and he better be on time.
I will be.
Am I understood, Mr. Duzan?
Yes, Your Honor.
Probable cause conference will be adjourned May 12th.
Same thing. Looks stern, but he just gave the guy a break and canceled the bench warrant because he didn't appear to court on time.
Thank you.
2022, 9 a.m. Bond continued.
Thank you.
I'll cancel the bench warrant.
Thank you.
Court calls the case of the people versus Ian. Is it Pasek?
Okay. Rob Dow on behalf of the people.
We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Ivan Pechek. Mr. Pechek, if you could state your name for the record.
State your name.
Attorney General, Audi Meyerstein.
Okay.
I'm sorry. I just really like the way the judge handled that. Okay. You'll see that they find that he's not competent, and we're going back and forth, but you see how they calibrate all of them. These are professionals, and everyone, the judge allows him to sort of talk over him and everything, and he realizes the situation. It's really actually very interesting.
All right. In this case, Your Honor, we are set for a competency review hearing. I believe that the court should be in receipt of orders finding that, in receipt of a report indicating that Mr.
Active military not required to enter court.
Indicating that the defendant is not competent.
Active military is not required to enter court.
We have no further evidence to present to the court other than
any evidence on behalf of the people.
No, Your Honor, we'll just stipulate to the report.
All right. The court, having reviewed the report, the court would find that the defendant at this time is incompetent to stand trial.
Rejected. Military is not required to enter court. Common law, Uniform Code of Military Justice, 10th of March. Presiding, acknowledge.
There is, however, reason to believe that this individual may be restored to competency.
That is really interesting to me. Obviously, he looks incompetent, and he's spouting all this stuff, which is clearly sovereign citizen stuff, at least to the extent I can gather what he's saying. He starts with the Attorney General thing, moves to common law, straight sovereign citizen tactics. But they say that he can be rehabilitated. So the report they have, they says he's currently not competent, but they think he can be rehabilitated. So they have to walk a fine line here. They don't want to dump on somebody who's not competent. And nobody is. They're very professional about it. On the other hand, they don't know if this is a shim-sham or, in the alternative, just something that we can get past and he can get back to it, which is a better outcome for everybody involved. So they're assuming he's not competent and acting accordingly, but he's leaving open the possibility that they can proceed in a normal manner after he's rehabilitated.
In the future, and therefore there's a reasonable likelihood that he can be restored to
military not required to enter court.
Period. The court will then set a
military not required to enter court. Common law.
Court will set a competency review
residing at Cole.
July 28th, 2022 at 9 a.m.
Thank you, Your Honor. It's July 28th.
Thank you. Yes, bond will continue at that. Thank you.
Thank you.
Well, there you have it. Another wild one in Cedric Simpson's courtroom this morning. There was a lot more than that. Those are just the things I could grab in the time that I had allotted. But that is an interesting call every day, and it really had some wild ones this morning. Here at Law Talk, we like to have fun with silly stuff that happens in court, and every once in a while, and completely by accident, I assure you, you might learn something. Thanks for watching.